Hello, welcome to the Society of Wetland Scientists webinar series. We're so glad that you could join us today. My name is Jen Favela, and I'm a senior wetland scientist at Wetland Studies and Solutions in Gainesville, Virginia. I've been in consulting for 12 years with a background in delineations and permitting for commercial and residential development. And along with Jody Burns and Gordon Shaw, two other webinar planning committee members, will be moderating today's Sackett Symposium. After some introductions, our symposium will be led by four highly experienced panelists in several presentations, followed by a question and answer session at the end. Our symposium today will be approximately 90 minutes long, a little longer than usual due to the high interest and complexities of today's topic. So just a bit of quick housekeeping. If you have any technical difficulties during the presentation, please comment in the chat box so assistance can be provided. There's a lot of folks joining in today, which can make it difficult for us to help everyone individually. With that said, if you're having issues hearing or seeing the presentation, we suggest you close out and re-enter the webinar. So let's begin by introducing our first panelist, Royal Gardner. Royal is a professor of law and director of the Institute for Biodiversity Law and Policy at Stetson University College of Law in Gulfport, Florida. He has worked on wetland law and policy issues for more than 3 decades, beginning in the Pentagon. Recent projects include co-authoring amicus briefs on behalf of environmental scientists and scientific societies. He was lead counsel for an amicus brief filed on behalf of 12 scientific societies, including SWS and Sackett versus EPA, as well as for the amicus brief filed for aquatic scientists and scientific societies, again including SWS, that the U.S. Supreme Court cited in the case of County of Maui versus Hawaii Wildlife Fund. Royal is a longtime member of the Society of Wetland Scientists, an active member of the Ramsar section, also serving in several volunteer capacities, and the recipient of 2018 SWS President's Award for work on the amicus briefs in the Clean Water Act cases. He is also the author of Lawyers, Swamps, and Money, U.S. Wetland Law, Policy, and Politics, which has a small cult following, and his book, Waters of the United States, POTUS, SCOTUS, WOTUS, and the Politics of a National Resource, will be published by Island Press in December 2024. So with that, Royal, take it away.
Thanks so much for the kind introduction, and it is a pleasure to be here. Let me preface my remarks while we're getting the PowerPoint set up there to note that these are my personal views and not necessarily those of any organization that I have represented or I'm affiliated. Fantastic. And once again, it's a pleasure to be here. And this is one of my favorite spots, Big Cypress National Preserve in the Western Everglades. Is it a WOTUS after Sackett? Spoiler alert, probably not. Next slide, please. So today I'll briefly review some history, then consider the case, and finally we'll talk about the cascading effects of the decision. Next, please. In about a 20-year period, the Supreme Court considered the question of which waters qualify as waters of the United States under the Clean Water Act. The most significant case was U.S. versus Rapanos in 2006, where the court split 4-1-4. There was no majority opinion. Justice Scalia articulated a very restrictive view of Clean Water Act jurisdiction, but he had only 4 votes. Justice Stevens favored a more expansive view of WOTUS, but he also had only 4 votes. And in the middle was Justice Kennedy, and he charted a middle course. A wetland or a water would be jurisdictional if it had a significant nexus to a traditional navigable water, and so the EPA and the Corps issued guidance adopting the significant nexus approach. In 2015, the agencies essentially codified this approach in the Clean Water Rule during the Obama administration, which the Trump administration then repealed in 2019. Next slide, please. The Trump administration adopted its own rule in 2020, which the Biden administration repealed and replaced in early 2023. And as regular as the tides, inevitably, After each rulemaking, litigation followed. And one such case was Sackett versus United States, which the Supreme Court decided in May of 2023. Next, please. The wetlands in question were about 300 feet from Priest Lake in Idaho and had a shallow subsurface connection to Priest Lake, which almost everybody, except perhaps Justice Thomas, would agree is a traditional navigable water. Applying the significant nexus test, the agencies concluded that the wetlands were jurisdictional, and a U.S. District Court and the Ninth Circuit concurred. The Supreme Court then agreed to hear the case to decide whether and to what extent wetlands are covered by the Clean Water Act. That is, are wetlands waters of the United States? Next, please. The Sackett's position was that a wetland is not a water. So this is my students and I standing in what is apparently not a water. Next slide, please. Many members of the regulated community filed amicus or amici briefs on behalf of the Sacketts. For the consultants out there, these are your clients. Next slide, please. And there were also briefs filed on behalf of the EPA, including one that my legal team and I filed on behalf of 12 scientific societies, including SWS, to inform the court about the consequences of adopting a restrictive view of waters of the United States. Next slide, please. I had the privilege of attending oral arguments. These were actually the first arguments open to the public post-COVID. And based on the questions from the justices, particularly Justice Kavanaugh, it was a little unclear about how they might rule. Next, please. But alas, in the end, the court unanimously rejected the significant nexus test, 9-0. All of the justices agreed on that point. The majority opinion, which was written by Justice Alito, adopted the test from Justice Scalia's plurality opinion in Rapanos. So there were 5 votes for that point. Justices Kavanaugh, Kagan, Sotomayor, and Jackson disagreed with the endorsement of the Rapanos test. There were also separate concurrences by Justices Thomas, Kavanaugh, and Kagan, but at this point, those are largely academic. In Rapanos, there was no majority opinion, and thus Justice Kennedy's concurrence in the judgment loomed large and became influential. Here, however, there are 5 votes to adopt a restrictive definition of waters of the United States, and so the concurrences really don't matter as much right now. Next slide, please. So what is that restrictive test? Well, first, the court said that waters are only those relatively permanent, standing, or continuously flowing bodies of water, such as streams, oceans, rivers, and lakes. Note what's missing from that list: wetlands. Next, please. The court said that wetlands are only jurisdictional if they have a continuous surface connection to a water that is a WOTUS in its own right, so that the wetland and the waters are indistinguishable from each other. Next slide, please. So what does this continuous surface connection requirement eliminate? In my view, non-floodplain wetlands, such as prairie potholes, precosins, vernal pools, Carolina and Delmarva Bays, they are out. Riparian floodplain wetlands that have a surface connection to ephemeral streams are out because ephemeral streams are not relatively permanent waters. Ephemeral streams themselves are out. Riparian floodplain wetlands that have only a groundwater or subsurface connection to a WOTUS or traditional navigable water are also out. Next slide, please. But there's this concept of indistinguishable. And what does this mean? The court stated that the Clean Water Act extends only to those wetlands that are, as a practical matter, indistinguishable from a WOTUS, where it's difficult to determine where the water ends and the wetland begins. And this is more than a mere rhetorical flourish. It's a central part of the court's holding or decision. Next, please. Next slide, please. Our amicus brief was the only one that addressed this issue and its consequences in detail. There's nothing in the scientific literature or in practice that suggests it's difficult to determine the boundaries between a wetland and, for example, a stream. Many of you attending today do these delineations on a regular basis. If you can delineate a wetland, you can distinguish it from other waters. And if you can distinguish it, it's not jurisdictional, if we're taking the Supreme Court at its word. Now, to be clear, I think that this indistinguishable requirement has no basis in statute, in science, or practice, but that's what the U.S. Supreme Court has decreed. Next slide, please. So, is this cypress dome in the Western Everglades a WOTUS? Next slide, please. I would say not. It dries out during part of the year, so there's no continuous surface connection with other water bodies, and there's even a road that separates it from other waters, so it's distinguishable. Next. Larger scale, what does this look like? Well, let's consider the Greater Everglades ecosystem watershed. I'm part of a team with my Stetson University colleagues in the National Parks Conservation Association examining the issue. And let me stress that these are preliminary results. This map shows the approximate coverage of the Clean Water Act pre-Sackett under the pre-2015 regime. Next, please. This is post-Sackett, applying the indistinguishable test. As you can see, it's a rather dramatic reduction in Clean Water Act jurisdiction. Next slide, please. This is consistent with other models and scenarios that are being worked on by other groups, including the Environmental Defense Fund. So I would commend to you to take a look at what they are doing under different scenarios. But in terms of applying the indistinguishable test or factor, this is the result. Next slide, please. So what are the downstream effects of Sackett? Well, first of all, there's no need to apply for a Section 404 permit to fill the vast majority of wetlands and many streams now, even if they were the subject of a previous denial or even an EPA veto. In my view, this is a near extinction event for federal regulation of freshwater wetlands under the Clean Water Act. But WOTUS applies to more than just Section 404. It's the jurisdictional hook for all aspects of the Clean Water Act. So there's no need for a Clean Water Act Section 402 permit or NPDES permit for discharges to non-WOTUS. Water quality standards and TMDLs do not apply to non-WOTUS. Next, please. 401 water quality certifications are not applicable to non-WOTUS. NEPA is not relevant if there's no other federal connection. The Endangered Species Act, it's a little trickier. The ESA Section 7 consultation is not applicable. But if you have an endangered species issue on your property, the ESA still applies, and so you may have to go through the Section 10 process. But if you don't have a WOTUS, well, then the historic property review would also not be applicable. Next slide, please. But there's more. The Sackett decision, I'd say, renders state assumption of the 404 program largely useless, at least for wetlands. The decision will also have an impact on wetland mitigation bankers in states that don't have an independent regulatory program. because essentially, if you're depending on the federal program as your economic driver, you've lost that. The bottom line is that responsibility for wetland protection has shifted almost exclusively to state and local governments, or at least it will ultimately once the dust settles. Next, please. Thank you. In response to Sackett, the agencies revised the Biden rule to remove the significant nexus test and to require that adjacent wetlands have a continuous surface connection to a WOTUS. The agencies, however, were silent about this notion of indistinguishable. How is all of this playing out in the field? My fellow panelists will explain. Next slide, please. But if you want to take a really deep dive into WOTUS, you're in luck. There's a book coming out in December with Island Press, Waters of the United States, POTUS, SCOTUS, WOTUS, and the Politics of a National Resource. It'll make a great holiday gift. Thank you, and I'll turn the mic over to my colleagues.
Thanks, Royal. Our next panelist of the symposium is James Thomas from Austin, Texas. James manages HDR's environmental regulatory practice in the South Central region and also serves as the firm's Clean Water Act permitting practice lead, focusing on monitoring regulatory changes to help their clients understand the potential impacts to their business. He is a senior professional wetland scientist with 30 years of experience, with an emphasis on state, federal permitting, mitigation, planning expertise in Clean Water Act Section 404 regulatory matters. And James has led and supported wetland permitting and mitigation projects for a variety of infrastructure types, including restoration in 12 Army Corps districts. James has served as a volunteer for 9 years on the certification review panel for the Professional Wetland Scientist and Wetland Professional and Training certifications. And additionally, he has served as the PM for the Fort Worth, Texas Rapid Assessment Method. James attended Texas A&M University and completed a master's researching wetland restoration methods on post-mined lands. Prior to joining HDR in 2000, James enjoyed smaller roles with regional consulting firms, conducting wetland delineations and environmental studies on federal lands throughout the southern U.S., Panama, and Puerto Rico, and is a wildlife and wetland biologist with Texas Parks and Wildlife Department on the Upper Coast Wetland Ecosystems Projects based in Orange, Texas. Take it away, James.
Thanks, Jan. I'd forgotten half of that stuff, but I appreciate you, the great introduction. I wanted to dig in to the idea of relatively permanent waters and that issue. I think Roy did a great job of framing the legal arguments, and he really emphasized that the court focused on the indistinguishable connection between wetlands and the ordinary high water mark of RPWs. So I think it's worth spending a little bit more time. Mine's probably going to be the shorter presentation, but I think it's really important because as practitioners, we probably need to understand what Sackett said versus maybe some of the interim guidance we're seeing, just to help guide our clients or make decisions on regulatory issues if you're in a state or a federal entity. So again, just to reemphasize what Roy presented in the language, in Sackett, the majority opinion really focused back on the Rapanos language and emphasized that in relation to the Clean Water Act, that their interpretation was that waters encompass only those relatively permanent, standing, or continuously flowing bodies of water forming geographic features that are described in ordinary parlance as streams, oceans, rivers, and lakes. And so I think it's important to focus on the order in which that is phrased, because the justices really emphasize how a fair reading and focusing on the order from significance is important. So when you look, obviously, tidal influenced areas, those are going to be permanent, considered permanent, standing water, and then continuous flowing bodies of water. So when I read standing water in that order, I take that to mean more focused on the permanent impoundments of water and not temporary standing or pooling water. And so I think that's an important context for us to move forward when we're evaluating, is there an indistinguishable connection to a relatively permanent water or an RPW? Obviously, we're in a period of substantial, I don't want to say confusion, but we're in the middle of that period after the ruling, a new ruling, where we're going to have to reset some of our thinking, I believe, as practitioners. Next slide, please. So again, the justices emphasize a fair reading of the Clean Water Act that considers Congress intentions, and they really focus on trying to tie back and quote the prior Supreme Court decisions, as well as some other legal decisions, to really demonstrate that consistency. And in going back and reviewing Rapanos and some of the earlier rulings on navigable waters, they really emphasize that the Clean Water Act extends to more than traditional navigable waters, but they refuse to read navigable waters out of the statute. My interpretation, and others, the longtime practitioners I've talked to, it's really a paradigm shift back towards waters that are a much more limited classification or class of permanent waters, permanently flowing waters, as opposed to maybe what we saw post Rapanos guidance. Next slide, please. Thank you. So there's a lot of discussion between practitioners and with the agencies right now about seasonal and how much flow is enough. I think it's worth noting that the majority opinion and the concurring opinions, I've read the opinions multiple times. I've done word searches just looking to try to look at it from several angles. They do not use the term seasonal nor duration of flow at all in reference to streams. They only refer to continuous flow and flowing. Although it does seem like they give some circumstances and severe drought where flow may stop, it's in normal conditions, it should be continuous flowing or have continuous flow or flowing. And so I went back and looked to, try to find out when this idea of seasonality or continuous flow, it seasonally came in, because I know right now I'm hearing from multiple districts guidance on 3 months or more, but that really came out of the immediate post-Rapanos guidance that came out in the JD form guidebook. When we were prepping for this, Roy mentioned that it probably came out of some language that Scalia, maybe in Scalia's writings on Rapanos. But that's really the first reference to seasonal flow I could find in relation to Clean Water Act jurisdiction. Of course, if you were practicing back in the 90s, you may remember the discussion of headwaters and above the headwaters, below the headwaters, which was on average 5 cubic feet per second. That's quite a bit of flow, especially when you look in the Western US. This is an example. This is Williamson Creek, right as you enter the recharge zone near Austin, at the Edwards Aquifer recharge zone, for those that are familiar with that karst topography. A very important aquatic system, I think we would all agree, from water quality to many residents of the state. But this has a lot of loss to groundwater, and it does not flow continuously, even on a seasonal basis. It certainly responds to major rainfall events and will flow, seasonally. So even a water as important as this, a fairly major stream or creek running into a critical aquifer recharge zone, as Roy mentioned, would probably not be meet that standard of continuous flow, even seasonally. Next slide. So there are certainly areas of uncertainty that are going to have to be worked out, watching what's happening in the courts, waiting for headquarters guidance. But I know that we're in a period, we're getting a lot of information about seasonal flow and how much constitutes flow. I think we just have to adapt for the next year or so as legal arguments continue to play out. But how does perennial and seasonal pooling factor in, those geologic differences where you're in a sandy area. Yeah, you may have a segment where you have a perennial or a pretty high order intermittent segment, and then it goes through a sandy or substrate where you get a lot of recharge and you lose that. How do those play in? I think my perspective is that the states really are going to need to step in and start determining what those water resources are that are important to them, both in the context of streams that may not meet that continuous flow provision, and really look at putting some protections around that. Because I agree with Roy and Bob is that you're likely going to see the courts taking a very finer reading of the Sackett case related to some of these waters. With that, I'll turn it back over to Jen and Bob.
Thank you, James. This is Jody, one of the other moderators. Our third presenter that we are honored to introduce is Bob Kerr. He is director of the Hampton Roads Division for Wetland Studies and Solutions and located in Virginia Beach, Virginia. A senior professional wetland scientist, Mr. Kerr has more than 3 decades of experience providing environmental services in Virginia. He has led environmental services for a variety of complex and high-profile projects and has served on state-level policy committees for topics regarding stormwater regulations, wetland regulation, and coastal resilience. In 2015, he testified before Congress about the Waters of the U.S. rule in Washington, D.C. His responsibilities include overseeing WSSI's work, which includes wetland delineations and permitting, mitigation planning and design, NEPA document preparation, ESAs, and permit compliance during construction. Mr. Kerr has a master's in marine environmental sciences from the State University of New York at Stony Brook and a BS in biology with aquatic sciences concentration from the State University of New York at Fredonia. Take it away, Bob.
Thank you, Jody. Next slide, please. I'm going to be talking about this concept of continuous surface connection, but a few of these slides are just for some background in case some of you aren't as familiar with the regulatory program as others. We are currently one nation under 2 systems. The states in green are those that are under the 2023 amended rule of Waters of the U.S. The purple-colored states, like Virginia, are those under the pre-2015 regulatory regime. So keep that in mind. You'll see references to that. But by and large, the agency's interpretation of continuous surface connection is pretty much consistent, regardless of which program you're in. Next slide. If you heard that, we have jets flying here. We're near a master jet airbase, so that's the sound of freedom if you heard it. I want to start by just identifying things that Sackett did not change. Traditional navigable waters, territorial seas, navigable waters, interstate waters, all of those definitions remain unchanged, as did the definition regarding impoundments of those waters, as well as the definition of wetlands. We can't hear your background. Okay. So the definition of wetlands has not changed either. I should say there are some states like Maryland and Virginia that regulate all waters and wetlands independently of the Clean Water Act. So some of these discussions have to take that into account. Next slide. The things that Sackett reconfirmed, as you were hearing from James, this concept of relatively permanent waters seems to be unchanged between Rapanos and Sackett, that both perennial and intermittent or permanent and seasonal waters remain regulated as long as they have an ordinary high water mark over the majority of their reach. Ephemeral conveyances are not regulated. Those, and I use the term conveyance for man-made or natural systems. If they are just surface water driven, they're flowing only after a precipitation event. They're not jurisdictional under Rapanos nor Sackett, but as you'll hear in a minute, they factor into the continuous surface connection. Next slide. Which brings us to what did Sackett change? As Royal mentioned, it eliminated the significant nexus test from the Rapanos case, and it created a two-step test for those wetlands that can be regulated under the Clean Water Act, which have to be adjacent wetlands. And then it also seemed to create a new indistinguishable standard for those wetlands. Next slide. So what is this two-step test that the Sackett case has created? What they said here, and there's a minor typo in this line 1, but you must have a relatively permanent water or other jurisdictional water that is connected downstream to a traditional navigable water. And then you must have a wetland that has, quote, a continuous surface connection with that water, making it difficult to determine where the water ends and the wetland begins. If you meet both of those, you now have an adjacent wetland at the head of that system. Next slide. So now I want to get into some policy memorandums, and there are some policy memorandums available for us practitioners, and I want to explain kind of where they came from. So in September of 2023, the WOTUS rule was conformed to meet with the Sackett definition, and then the Corps then began resuming issuance of AJDs, or approved jurisdictional determinations. In April the following year, they published a memoranda that gave a kind of a status of the process of issuing AJDs between the conforming rule being published and about the week before this memoranda came out. What they said is that 948 AJDs had been issued under the 2023 rule, and that 1,728 had been issued under the 2015 regime. There were 166 of them that had been elevated to headquarters for review. 73 were resolved, 93 were unresolved at the time. And as of today, or I'm sorry, as of the end of July, there are 9 AJD drafts that have been taken to headquarters of the Corps and EPA, and that as a consequence of the issues examined in those cases, the headquarters of the agencies have issued policy memoranda. And that's what I want to spend the balance of my time talking about, is what is found in those policy memoranda. Next slide. And these are hard to find, but they are on both the EPA and the Corps webpage. I broke them up here into readings of the policy memos from the 2015 regime versus 2023, but they're virtually identical. The alphanumeric numbering after each regime is the policy memoranda project number. So I want to reference those for you as we go through. The first one for the pre-2015 regime was from the Galveston district. And the memo says that non-relatively permanent ditches and culverts, alone or in combination, can meet the continuous surface connection requirement for wetlands evaluated as adjacent wetlands. And it goes on to say, Sackett does not require the agencies to prove that wetlands and covered waters are visually identical. Indeed, as Sackett notes, courts have long regarded wetlands that abut covered waters as meeting the continuous surface requirement. So they're basically saying you can use non-jurisdictional ditches and culverts alone or in combination to meet this continuous surface connection test. Under the 2023 rule, they issued NAP 2023-01223, which is from the Philadelphia district. And again, they say, depending on the factual context, the requirement can be met when a channel, ditch, swale, pipe, or culvert, regardless of whether that feature is itself jurisdictional, as a physical connection that maintains a continuous surface connection between the adjacent wetland and the relatively permanent water. And So you can see that the concept that Royal was talking about, which many of us thought was the way Sackett was written, that you have to have this continuous surface connection between an RPW and a wetland, seems to be different than the way the Corps and EPA is interpreting it, because they're allowing that connection to be via a non-jurisdictional system, as you'll see in a minute. Next slide. So you might ask, well, what about that indistinguishable concept? Well, in fact, that's addressed in these policy memorandums also. And it says, quote, the word indistinguishable, end quote, is not a separate element of adjacency, nor is it alone determinative. The term informs the application of the continuous surface connection requirement. And again, I give you the sources of those two policy documents or policy memos, one from the Kansas City district and one from the Philadelphia district. Next slide, please. So again, they go into specifics and say, Sackett explained that wetlands are, as a practical matter, indistinguishable from waters of the U.S. and therefore are themselves covered when there's a continuous surface connection between the wetlands and the covered waters. So what I deduce from this is that the agencies are basically relying on the fact-specific analysis for continuous surface connection, and that once an agency personnel determines there is a continuous surface connection, the indistinguishable standard is basically met by default. So the test really focuses on, do you have a continuous surface connection? Next slide. So I'm going to give you two examples of one where they have found continuous surface connections, actually two different ones on a project. And then I'll show you one of the policy memos where they confirm there is no continuous surface connection. So this one is from the Philadelphia district, and it had two cases on the same property. They were remote and not connected to each other. One was a wetland that had a direct pipe connection from it to the head of a relatively permanent water. And the Corps found, the agencies, the headquarters found to have a continuous surface connection. They felt the physical indicator of flow was the pipe, and the rationale was that, quote, pipes provide evidence that sufficient levels of surface flow are occurring. The logic was otherwise you wouldn't need a pipe. The pipe helps protect things like roads from damage from flowing water, so the pipe is sufficient to indicate flow. They went on to say that more than one such feature could also serve as a continuous surface connection where together they provide unimpaired, continuous physical connection to a jurisdictional water. Lastly, the length of the pipe was 70 feet. And they felt that that was a relatively short distance for a continuous surface connection. Now, the other case on the same property was a wetland connected by a man-made swale to an impoundment of a relatively permanent water. And here they found that you really need to look for the frequency and volume of flow, and that on the day of inspection, water was actually flowing in this ephemeral swale. They came out and said the swale was non-jurisdictional, that you do not need to be out there the day it's flowing or the day it's raining and flowing, but that you could use that as a element of your analysis. And there's a typo here. It was not 300 or 35 feet. It was a 350-foot length swale. And in this case, they found that that distance, roughly the length of a football field, is also relatively short and sufficient to be a continuous surface connection. So next slide takes those words and gives you some images. These are my depiction of the words of the memos. I think when you go read the memos, you'll find the agencies have done a very good job of explaining the physical situation. So I don't think these drawings differ much from the real conditions out there. But in the upper left, you see this wetland draining directly through a pipe to the head of an RPW, and I think that was important to the agencies. It contributed flow to the RPW itself. It was the only wetland up at the head of it. And again, they considered that jurisdictional as an adjacent wetland. And then the case to the lower right is this wetland separated by 350 feet to an impoundment of an RPW via a non-jurisdictional swale. That swale picked up runoff from adjacent uplands, the memo said, but in this case, they felt they had enough evidence that the wetland was found to be adjacent. Next slide. And I think what you're going to be left with at the end of this is you're evaluating issues like flow significance in an ephemeral conveyance, which can be challenging. And here's a great example of a challenging project. This project is, is in the Kansas City district. The project had three wetlands interconnected by an ephemeral conveyance, which then drained to a roadside ditch, which then drained to a ditch on the side of a railroad, which then discharged to farm ditches that were partially piped. And in this case, the agencies found that the flow frequency and duration indicators were weak, and that the distance between the wetlands and the downstream relatively permanent water, the connection was tenuous, extended, and they said the distances were long. So if you go to the next slide, you'll see these three wetlands, WD5, 4, and 7, having a ditch that runs, or conveyance that was deemed ephemeral and non-jurisdictional running through them, leaving the site, discharging to a roadside ditch, which then discharged to a railroad side ditch, then to a farm ditch. And in this case, they felt the indicators of flow frequency were weak, the indicators of flow duration were weak, and that the long distance and chain of features was too extended and tenuous. So with that, if you go to the next slide, I've tried to summarize the indicators that they have mentioned in these cases, but there are many more available to you within these 9 memos, but they typically are repeated, so there's not that many more. These are kind of the major elements that you should be looking for in evaluating the continuous surface connection. And with that, I'll send it back to Jody.
Hey, Bob. Our next presenter, our final one for today, is Leandra Cleveland. She is with HDR and based out of Blue Ash, Ohio, and is program lead for the Freight Rail Environmental Area. She is a PWS that has been delineating and permitting waters of the U.S. for over 24 years. She spent her career working in the private sector as a scientist and project manager across numerous geographies and project types. She's a very active member of the Society of Wetland Scientists and Society of Wetland Scientists Professional Certification Program. She's served as a 2-term national secretary, which is awesome, and also as president of the SWS PCP board. Thank you, Leandra, for being a part of today's symposium.
Thank you, Jody. So we've heard a lot of the technical piece of how some of this might be interpreted from the courts, and just wanted to talk very briefly actually about how this may actually play out with some of the districts. So you can go ahead and advance. So for those of you who maybe have not looked at a U.S. Army Corps district map for the entire United States, just a couple kind of reminders. We have about 45 districts, and those boundaries are based off of watersheds, which basically creates a scenario where we have districts, and almost all of them do this, crossing over several state boundaries. And the implementation of that 2023 rule is really largely based on states. So go ahead to the next slide. As Bob already showed this graphic and kind of talked about this, we do really have a divided country in terms of which states are utilizing this and which ones aren't. So just as a recap, about 27 of the states, which are shown in purple, are under the pre-2015 regulations, and 23 states shown in green, plus the District of Columbia and US territories, are under the 2023 rule. Next slide. So if you take an example like the Walla Walla district up in the Pacific Northwest, it crosses 7 states. And of those 7, 4 of them, Washington, Oregon, Nevada, California, are under the 2023 rule. 3 of them, Idaho, Wyoming, Utah, are under pre-2015 regulations. As has already been stated, you know, they're very similar to each other, but when it comes to the type of policy that you may see in the future coming out of the US Army Corps, it may not necessarily be issued on a district-wide basis. We do truly have kind of some slight nuances between these two. It's not really clear if it will become district to district, you know, how headquarters is going to necessarily issue that across the country. Or if it's going to be a little bit more state specific. I mean, for those of you who are practitioners processing these permits or work at the Corps, you know, you're very familiar to dealing with very state specific components when it comes to the 401 water quality rules, since those are have delegated authority to the states, and they create basically differing regulations for each state, even though you may be getting a 404 permit from an actual just district. But when it comes to what are we actually seeing in terms of maybe deviations from the Sackett ruling, the reality is that we're not seeing it really published in writing. You know, Bob talked very clearly about some examples that have come out. Those are definitely maybe, I don't know if they're necessarily want to call them deviations, but maybe they can be clarifications. In many ways, they just make everything a little more confusing. So right now, if you were to ask districts and talk to them, you may get a very different response. You may get some indication that they might look at things in a certain way or a certain light that may be different than another district that you work in across the country. But at the end of the day, none of that is actually, we're not seeing that in writing. And I think that's where it's going to become a little bit interesting as we move forward to really see how this plays out with actual guidance. Certainly as for those working and issuing JDs, that has to be a little bit challenging on their end, but certainly from the practitioner side, you're also having challenges in trying to communicate that with clients, as well as just doing the job, you know, being able to pull things together and make reasonable decisions to help people through this process. The one thing we are seeing though is getting a JD now is taking longer. So some places you could get them in just 2 months. Other times it might take you 4 months to get them, but there was some consistency in how long it was taking to get all those things issued. But now we are definitely seeing almost a doubling of that time. And it's not because they're complicated ones that are being requested. In many cases, these are very clear-cut, isolated wetland scenarios that should really not be a question at all, but those are taking longer to get. So from a timeline perspective, that is definitely something that we're seeing and having to factor in. Next slide, please. And I know we've alluded to this before, but it is probably going to be more up to the states moving forward, as well as even local jurisdictions, to really try to formalize some sort of wetland or waters of the state permitting program. Currently, there are 24 states that have a formal program in place. These states have largely had this for quite a while. We haven't seen too many in recent years. The remaining states, 21 of those rely exclusively on Clean Water Act Section 401 water quality certs. So if you do not trigger that 401 water quality cert, there won't be anything for the state to kind of weigh in on with regards to permitting waters of the US. 5 additional states also rely on the 401 for their ability to comment or be part of that process, but they have a very robust coastal program. I think Louisiana is probably the best example or a good example of this, where you have a state that does not have its own state permitting program. However, they have a very robust coastal program. So unfortunately, until we see maybe a few more states kind of try to fill that gap, we are going to be kind of left with a lot of waters of the US that had been protected, maybe not being protected moving forward. And then local municipalities, for the most part, they will often mirror what the state rules are. So typically in states that have a program, the local municipalities, whether that is something that is dictated by state law or otherwise, they will have things in place. For the most part, those rules are often a mirror, but sometimes they can be more restrictive. But that may also be an opportunity in states that don't currently have a wetland program for them to actually pass some sort of rulemaking at the local level to provide some protections. And with that, I'll go ahead and turn it back to Royal.
Thanks so much. So let's now take a look at some post-Sackett cases in the courts. And the courts are perhaps taking a slightly different view than that of the agencies. So first, Lewis versus United States, and that is a Fifth Circuit Court of Appeals decision that came out in December of 2023. The property has been subject of jurisdictional disputes and AJDs for about a decade. The government was well, at least as the court had described the property, that the wetlands are adjacent to a roadside ditch and a culvert. It's connected to an unnamed tributary, then to a creek, then to Collywell Bay, which is a traditional navigable water, but about 15 miles from the site. The Corps actually withdrew a 2020 AJD in part, I think, to try to moot out the case. But the appellate court concluded that the matter was not moot and decided the case on the merits. And it did so in part based on photographs, which the court stated showed no continuous surface connection to other waters. And note for a moment the implication here that with the court, by relying on a photograph, seems to suggest that it will not be entertaining any arguments equating continuous with seasonal, since a photograph just captures only one moment in time. The court observed that it was not difficult to determine where the water ends and the wetlands begin because there was no connection whatsoever. So there was no remand back to the agency, simply an order to the district court to enter judgment in favor of Lewis, the property owner. The second and third cases here involve challenges to civil enforcement actions. So Chameleon involves 3 tracts in Virginia where the wetlands had a continuous surface connection with an unnamed, relatively permanent tributary that led to named creeks that then led to traditional navigable waters. And the court highlighted the indistinguishable requirement, sort of used it as an umbrella for the test that it applied. It said that the wetlands must be indistinguishable from a WOTUS in order to qualify as a WOTUS itself. And so that means that it has to be adjacent to a water of the United States, and it has to have a continuous surface connection, such that it's difficult to determine where the water ends and the wetland begins. The court concluded that the government's complaint, the civil enforcement action that was being brought against the entity, lacked sufficient factual details about the connection and therefore dismissed the civil enforcement action. Similarly, in Ace Black Ranches, the U.S. District Court in Idaho dismissed an enforcement action for lack of sufficient factual allegations in the complaint. Ace Black Ranches allegedly constructed road crossings, cleared and leveled, and conducted sand and gravel mining operations in adjacent wetlands, adjacent to the Bruneau River, which is a traditional navigable water. The court characterized the issue as whether the government had sufficiently alleged that the wetlands were indistinguishable from and have a continuous surface connection with the river. So the court was not equating the two and saying they're the same. The court was saying that the Corps is going to need to explain how it satisfies both of those standards. So tellingly, the court stated that nowhere does the government specify that these wetlands have a surface connection with the river to be considered indistinguishable from the river, thus satisfying the adjacency test. And the court specifically asked, how are the wetlands indistinguishable from the river? Because the government had failed to provide any specificity, the court dismissed the enforcement action, but gave leave to the government to file within 30 days, and the clock is ticking. Now, a case where the government did win, at least defeated an attempt to have a preliminary injunction affecting the conforming rule, was in White versus US EPA. And so this case involved a challenge to the conforming rule itself. And here, the property owner was subject to an ongoing enforcement action and sought to defend by seeking to invalidate the conforming rule. In my view, that was a curious strategy because the conforming rule on its face is not inconsistent with what the Supreme Court said in Sackett. It simply is silent on the question of indistinguishable. In any event, the property owner asked for a preliminary injunction to temporarily void the regulation, the rule, but the court denied that request. And in doing so, the court found that White had not shown a likelihood of prevailing on the merits. White had argued that to be adjacent, the wetland has to have a continuous surface connection, but also be practically indistinguishable from the water that it is connected to. The court looked at it slightly differently, stating that the consequence of a continuous surface connection renders the wetland indistinguishable, which is perhaps more consistent with the memos, but I'm not entirely sure. But it is certainly inconsistent with the later cases of Chameleon and Ace Black ranches. So there appears to be a developing split in the district courts. But also remember that procedurally, it's in a different context. In White, the property owner was seeking to invalidate the conforming rule itself, claiming that the agencies had acted arbitrarily and capriciously. That's ordinarily a very high burden. In the other cases, the courts were considering the agency, considering as appeal challenges, essentially. Next slide, please. One ongoing enforcement case I'd suggest that you keep an eye on is out of Martin County in Florida, which is United States versus Sharfie. I happen to have former students on both sides of this case. And I bring it to your attention because the property owner has specifically flagged for the court that the easiest way to decide the case is that the wetland is distinguishable from the drainage ditch that it adjoins. So essentially they're saying you can tell where the ditch ends and the wetland begins, and if you can do so, the wetland is not jurisdictional. So that I suggest is a case to keep an eye on, and I'll turn it over. Thank you.
Wonderful. Thanks, guys. Those are really great presentations. And now we're going to be switching gears just a little bit and starting with you, Royal. What's the takeaway message that you want our audience to leave knowing?
So, well, I think the takeaway is that I mean one point is that Congress could resolve this. This is a statutory interpretation question, but waiting for Congress to do something on this, I would suggest would be like if you're on death row and you're waiting for the call from the governor. It's not coming. So you can't expect Congress really to step in this. And I think the agencies have very little flexibility. They're being quite aggressive in the memos, as Bob talked about. And I think the courts are going to look at that quite skeptically, as we've seen in a couple of enforcement actions. So really, it's shifting to the states, I would say, in terms of wetland protection. So if you're concerned about freshwater protection, I would put your energies into focusing on what's going on at the state and the local level. Thanks.
Thanks, Ryle. All right. How about yourself, James?
Yeah, thanks. Yeah, I would agree that energy is probably best spent at the state level. You know, when I first reviewed the rulings the opinions back in 2023, my initial thoughts were that very similar to what Roy showed on his two graphics, which are pretty stark differences, pre-Sackett, post-Sackett. I thought it was going to be a major change. And then what we've seen over the past year or so, it seems like the concept of continuous surface connection kind of been a way to still maintain a significant nexus evaluation, but by a different name. And I think the courts, what we're seeing in these recent cases, especially the Lewis case, tell us that the courts are going to probably lean closer to what the Supreme Court ruling says on that wetter, continuous flowing and indistinguishable connection characteristics than maybe what the agencies are currently deciding on in some of the memos that Bob went through. And so I would say, as conservation-minded folks, it's interesting to me in the first month or two, the EPA put out a notice to states to really encourage them to start to look at their own water resource protection programs, streams and wetlands. And I think that's the right way to go. I think the society and other practitioners really want to start watching and looking for state and even local related, county related programs that may be able to fill this gap if that's important to you.
Thanks, James. All right, Bob?
Yeah, I think the one unfortunate situation for all of us, both the folks at the agencies in the field and the consultants and the landowners, is we don't have a definition of continuous surface connection. It's not in the 2023 conforming rule. And unlike Rapanos, the agencies have not prepared a memoranda for the field that provides us all with some guidance. Now, it might be that that's because of another Supreme Court case about Chevron deference that basically brings up the point that when does an agency overstep either regulations or court cases? And I think in this case, the agencies are kind of issuing these project-specific policy memoranda on a project-by-project, fact-specific decision-making basis to kind of help shore up their position so that they're issuing some guidance, but they're not coming out with kind of this broader policy. That I do not know as a fact. I just wonder if that is going into their thinking, because this is the first time in a long time that we don't have kind of broader guidance on how to interpret something. You can think back, significant nexus, we had a 108-page document on how to interpret significant nexus, and I dare say continuous surface connection is going to be, it's going to come up in decisions as frequently as significant nexus is, or did. So I'd look for more guidance, but I think it's going to be slow in coming, unfortunately.
Thanks, Bob. Then Leandra.
Yeah, I think there's takeaway for me is really that states are going to have to really fill this in. I feel like I'm just going to repeat what everybody has already kind of said for takeaways, but I don't think that we're going to see some sort of clarification come anytime soon from the regulatory agencies. Certainly if something does, it'll probably end up back in the courts. But really, this is a place where states can really step in and kind of bridge that gap, and also find ways to regulate what is important ecologically for that specific area as well. Be able to have a more specific kind of approach that works for them and the resources that they have.
Thanks, Leandra. It was great hearing from all of you in your presentations. So we're going to move on into our question and answer portion of our discussion today. And we've had plenty of, obviously, questions coming in on this topic. So, we've heard that there's a connection between an adjacent wetland and a relatively permanent water can be underground. Is that true? It might be a good question for you, Bob.
Thanks, Jen. Yeah, the guidance has clarified that a subsurface connection can only be used between two wetlands to determine if they're interrelated. And if they are, then that dual wetland system can be then evaluated for adjacency as a whole. When you're dealing with a continuous surface connection, that discussion's between a wetland and a water, and the agencies have clarified that that has to be a surface connection. It cannot be a subsurface connection.
Bob.
Okay, next question. I think this might be for you, Leandra. Are we seeing that Section 401 and Section 402 permit applications are also declining in line with Section 404 applications from your experience or from what you've seen?
I would say, Section 401 would certainly decline and would certainly follow that pattern with 404 because they are tied together. So as you have less 404 applications, in theory, you would also have less 401. I mean, if you're talking about nationwides, that's already been, they have blanket coverage, but individual permits, we would see that lessen. I'll be honest with you, I do not know on 402, but we did mention, I know during the presentation, I mean, if you have to get a 402 permit because you may have the potential for impacting a water of the US with those construction or operational activities. So if it's not a waters of the US and you're not in danger of doing that, you could potentially see a decrease in that. But I don't know if anyone else on the panel has had direct experience with the 402 program relative to Sackett yet.
Yeah, I can add in because I have fielded a few of these questions. It seems like what we're seeing on 402, remember that's a pretty broad program. It covers construction, stormwater, it covers all sorts of MPDS, effluent discharges. I think you're not going to see as much change on the construction stormwater because a lot of times that's handled at the local level by cities, and the states that I've looked at haven't really updated. They're not really tracking that Sackett is going to or affect that program. I think the first part of that program that's likely going to be affected by this decision is going to be when you're looking at effluent discharges and whether that receiving water is a water US or not, and how that may play in, and if some of those are challenged. But I think those are probably going to play out in courts because I'm not seeing the states that regulate those programs really update their information on their websites related to MPDS yet. And that's based on the region I work in. That could be different in other places, but it just seems like the 404 practitioners and the core regulatory program are kind of the first groups that are dealing with this. I think it's probably coming for the MPDS for multi-sector general permits and effluent discharges, but it's not there yet.
Thanks. So we have another question asking if someone could provide clarification on the difference between adjacent and abutting, and which or if both are jurisdictional.
I'll start that one. That's a great question. So adjacent includes abutting. So if a wetland physically touches the stream that is an RPW, then it is adjacent, kind of adjacent by fact. This continuous surface connection kind of extends that distance. It used to be, and I might be paraphrasing, but in the old days when I had no gray hair, adjacent meant abutting, contiguous, and nearby. And the question has really always been, what in the world does, how far is near? How near is near? So abutting wetlands have always been considered adjacent. Then the question was, well, what about if it's separated by a natural berm that a river creates as a consequence of flooding on a geologic time frame? It's neighboring, it's not touching. And traditionally, the Corps had regulated those types of wetlands back to the 1986 when the program started. And that's where Sackett is taking a different view. Then the other question is, well, what if there's a break in that berm and the wetland is immediately on the other side of that break? Is that a continuous surface connection? So that's kind of how the question evolves when you move a wetland from abutting, directly touching the water, to slightly remote from it. That's a good question.
Thanks, Bob.
If I could add on to that, I agree with Bob. I mean, I think Sackett has answered that question with respect to neighboring, and neighboring is not adjacent. They defined adjacent to be abutting, actually physically touching. So if you're dealing with a wetland on the other side of a berm, that's not jurisdictional. Justice Kavanaugh sort of raised this in his concurrence and said, well, what about these wetlands? Well, the court answered it, and the answer is they are not WOTUS.
All right. Next question. I think this might be for Royal based upon your specific presentation. Is there a reference you can provide for the indistinguishable maps? I think it might have been the map you created about what waters are not indistinguishable or are.
Right. So that is not in a publicly available report yet. We expect it will be out in the not too distant future. But if you want to take a look at an excellent tool that's online and currently available, you can go to the Environmental Defense Fund website. If you Google Environmental Defense Fund and WOTUS and map, you will come up with their mapping tool, and you can take a look at it state by state and under different scenarios to see what the impact of Sackett would be on jurisdiction.
Thanks. All right, I'm trying to get through these questions here. So we have maybe a situational question, but in rural areas, farm ditches can be very long, yet have relatively permanent flow. Do both relatively short and relatively flow both have to be met, or just one? And which one is more relevant? Because a lot of farm ditches, at least in the Midwest, where streams have been channelized due to land use changes for roads and crops. That's a lengthy one. Does anyone want to tackle?
I could try to start. So based more on the reading of Sackett, I think flow, relatively permanent flow, is going to be important. I still think if you can determine that it's a channelized stream, that historically, looking back at historic maps, whatever you could find, if you could show that replaced a natural stream that was likely also relatively permanent water with continuous or long seasonal flow, duration flow, however that will eventually be defined, I think that it's likely those will continue to be waters. I think if you look back and if a ditch was, even in the EPA's guidance that came out right after Sackett, it exempted ditches without really consideration of length that were excavated in predominantly upland areas. And so I think you have to build, go back and look at the historic maps and what you can find for that area. Was it predominantly wetland? Was it, that would have been potentially connected to an RPW? Was it an RPW? And kind of tell the story of the history of that particular water.
Yeah, James, I think that's a great answer. I'll add to that. The thing that appears to occur there are two examples the headquarters have put out that deal with two cases that are non-jurisdictional, where the continuous surface connection are ephemeral, and not only are they long, but they receive contributing drainage downstream of the wetland, and yet that system is still ephemeral. And I think the subject of flow is probably the first thing they're looking at. But if it's an ephemeral reach, let's say James runs out and looks at it and comes back and he tells me, gee, it's not a channelized stream, it's just a ditch. I think the next thing we would look at is, okay, how long is that ditch connection between the wetland and the relatively permanent water? And along that distance, does it receive other flow from other ditches? Are those, ephemeral or not? And then downstream of those, is it ephemeral? And the agencies seem to be, they haven't kind of explicitly said it, but if you get to the downstream end of those systems and it's still an ephemeral connection, even though you have additional drainage going to it, they've been reluctant to consider that a continuous surface connection back up to your wetland. So I think the longer it gets, if there's contributing drainage, the more tenuous the connection is.
Yeah, and I think I agree. I do think that it's important to look back at the facts of the Sackett case and realize that wetland was only 300 feet from a TNW. And a lot of what we're seeing in these memos seem to be very similar, if not more tenuous, than the facts in the Sackett case. And so I think if you don't have relatively permanent flow, or at a minimum, more than a seasonal flow, however that is defined, you're on thin ice as far as calling those waters US if it were to go to court. I'm not saying they won't be called potential waters US in some districts right now, but what we're seeing legally, based on what Roy has highlighted for us, is most of those are getting challenged successfully.
Okay, next question. I think this may be for Bob. Has the government provided any exhibits for these memorandums that they have published?
They are not included with the memorandum. So they don't at the headquarters level. What they have said is that if you go back to the district offices and go to their website for AJDs, which are supposed to be posted, that the exhibits would be there if they posted them. And we've just not had the time to do that. I should say, I mean, that's one of the difficulties I think we're all in now as a consequence of not having guidance, like the issue James and I were just talking about in this, having exhibits. That's the kind of thing a national guidance would help everybody with.
And I'd like to point out that one of the concerns the court had about the Clean Water Act and the definition of WOTUS was notice to property owners. The court talked about the severe criminal penalties that might be imposed. Now, I think that concern as a practical matter is overblown, but that's what the court expressed concerns about, is providing notice to property owners. And the aggressive stance that the agencies are taking is not giving notice. the aggressive stance that's being taken in some of these memos. For example, suggesting that pipes can establish a continuous surface connection seems to be inconsistent with Sackett.
So here's a good question for our folks in the field. Any changes in data collection delineators should focus on under Sackett while they're out doing their delineations?
If you want to go back to my summary slide for a second.
Uh-oh. Might be asking a lot here, Bob.
Okay, if not, that's okay. I can read from it. The difficulty, to be quite honest, is they're asking for information about flow, duration, and intensity on an ephemeral feature. Because if it's an RPW, you've already got, and it has an ordinary high water mark, it's already jurisdictional by fact. So you don't need this kind of extra data. So you know, they're asking about what are the physical indicators of flow duration? What is the flow path? Is it simple? Is it direct? Or is it additional contributors? Length and type of connection. And again, like Royal was saying, I mean, the relatively short examples that were to be jurisdictional are all 300 feet and less. Now, that's only because there hasn't been a case for 400 feet, 500 feet, 700 feet. And then the non-jurisdictional ones started at 1/4 mile approximately. But again, there's a big gap between 315 feet and 1/4 mile. So, you know, we're not making it up as we go along, but we're finding it out as we go along.
Yeah.
Thanks,
Yeah, I think,
Bob.
you know, I've been helping in some of our regions as they start up big delineations, and I'm telling them, our teams, collect whatever information you can on flow. And if you have, you know, a lot of our projects, if you're a practitioner, you get a delineation project and you're out for 1 to 2, 3 weeks, you know, typically that's a large project. And you can't necessarily choose when you're going to have access. You're not going to be out there. Either you're going to be out there when it's wetter than normal or drier than normal. Very seldom do you hit whatever the normal is, and you're trying to make these calls. So I said, you know, really focus on the hydrologic connection. Wherever you're close to an RPW, take more data points, and talk to the land managers that are out there more often and get anecdotal information from them on how often does this flow in most years. The other thing, and the reason I say, you know, take more delineations, is delineators, what are we doing when we're delineating wetlands? We're looking for the 3 criteria, and we're distinguishing between hydrologic changes, plant community changes, soil changes, even within one wetland. And those are distinguishing characteristics when we delineate. And so when you're talking about indistinguishable between an RPW and a wetland, you know, my initial interpretation when I read the Sackett ruling was, well, anything above that first topographic break, first vegetation change above the ordinary watermark, those are going to be out. That's not necessarily where we are now, but I think the courts are probably going to take us that way. And so I think collecting more data points at those transitions near streams is going to be really important for the coming years.
I agree. Document what you see in the field.
I know we're getting close to the end of our time. I wanted to read 1 or 2 that had comments. The file numbers for the regulatory guidance memorandums from HQ can be FOIA'd, which means you can ask for them from the associated districts, and you can review the entire file, site visit photos, and exhibits. So good to know. One other thing, I think it had to do with the flow question, which it seems like that's what we're kind of talking about and around. Someone had some experience with the Corps that said the term continuous was used as a spatial definition, not flow, it was not temporal. So that wetlands that are dry later in the season that are still connected to WOTUS down slopes are still considered WOTUS. So, okay. Was there anything else, Jen? Did you need
Well,
us to?
I think that spatial versus temporal is, that's a big difference, I think, between where the courts are
Yeah.
and where the agencies are. I think the
Yeah.
courts are thinking, and you know, Roy may want to weigh in on this, but courts are thinking it's temporal, not horizontal space. So.
Okay.
All right. So I will hand it over to Gordon here. Thank you all for answering all of our questions and your presentations. And here you go, Gordon.
All right, thank you. We'd like to thank all our presenters today, Royal Gardner, James Thomas, Bob Kerr, and Leandra Cleveland. Thank you for your time and for your presentations. We'd also like to recognize our SWS webinar series sponsors today. Cattails Environmental, Davy Mitigation, and EcoBot. We greatly appreciate your support of our sponsors. You can find more information about our sponsors at their websites here listed here on this page. We encourage you to visit, like, and follow the sponsors. We do have in SWS, we have some upcoming webinars. Our next English speaking webinar will be a presentation, an international presentation on assessing anthropogenic impact on NASCAR wetland and proposing conservation measures. And that'll be by Dr. Mahamuni on October 17th. We do also have international presentations. We have one in Spanish. So we have a Spanish webinar coming up on September 25th with Sergio Alejandro Guarin Torres and Jenny Patricia Velosa Torres, giving a presentation on the gobernanza ambiental y evaluación del riesgo ecológico de los humedales de la sabana de Bogotá. Or in English, environmental governance and assessment of the environmental risk to wetlands in the Bogotá savanna. We encourage you all to check out the SWS website and social media channels to learn more about these and upcoming other events, other webinars. As a reminder, each of you who registered for this webinar will receive an emailed survey about the webinar. We encourage you and please request that you complete the survey and you'll receive a certificate of participation and also give you an opportunity to provide your feedback on the webinar. We're very interested in receiving your input. Thanks again for the exceptional presenters today and to our audience for participating. We hope you have a wonderful day. Thank you. Bye.